I'm sharing the link here with everyone so that if you want to share the link onward of the YouTube channel, that's there. And we will start broadcasting on the webinar itself in about 10 seconds. Broadcasting now. Over to you, Vignesh and Rajat, who are both on mute.
Yeah, good evening, everyone. Welcome to the grand finals of the 13th NLS Trilegal International Arbitration Moot. We're extremely pleased to have you all here. Today, we hope to see a wonderful face-off between two of the most talented teams in the competition. And we have a stellar finals panel put together. Let me just do a quick line of introductions before we begin. We have Mr. Shank Sengupta from Trilegal, who's part of the disputes team. We have Ms. Sharina Petit from Norton Rose. We have Mr. Patrick Taylor from Debevoise and Plimpton and the International Arbitration Team. We have Mr. Tom Snyder from Altamimi. And finally, we have Ms. Sapna Jhangiani QC from Clyde & Co. We're extremely glad to have all the panelists here on board, and we're really thankful to them for taking the time out to judge the moot despite it being on a Sunday. And best of luck to the participants. We hope the finals turns out to be a wonderful competition, and we hope all of you take away a brilliant learning experience from interacting with all the finals judges. Best of luck. I will be turning off my video, and I hope, and I will ask the tribunal chair to take over. Could the teams meanwhile tell us the split speaks so we can put it on the chat box for the benefit of the judges?
Can we put it ourselves, or?
Oh yeah, you can put it yourself as well. That works.
All right.
I think I will just be the tribunal chair, actually. Just realized that my colleague isn't here yet, but I will be happy to chair the round. That's not a problem. And I presume the order is RCCR. Can one of you confirm?
Yes, we have decided on RCC.
Okay, and you will have the rebuttals separately, which is you will have procedural rebuttals first, and then you will have the merits rebuttals.
Yeah, but both at the end of the round after all
both at the end
have
of the round.
Yeah.
All right. Yeah. Can the claimants quickly tell me the split time? Okay. All right. I've gotten the time splits, and I will keep updating the tribunal with the time splits by putting the time left on the chat box periodically. So I would request you to keep an eye out for it. And if I really need to grab your attention, I will use the raise hand feature on the. Okay, I'm afraid it's not available right now, but I will keep putting it on chat box. I'd request you to keep an eye on it periodically. Thank you so much. I think we can begin with the rounds. I will ask the respondent speaker 1 to go first. The respondent speaker has 22 minutes. Over to you.
Good evening, Learned Tribunal. Am I audible?
Yes.
Thank you. My name is Akhilesh Menezes, and I will be speaking on behalf of the respondent today. in the arbitration proceedings. I will be making submissions on the procedural issues. At the outset, I'd like to state that I'm very glad that we can conduct these proceedings over a video platform despite the pandemic that is happening across the world. So the three issues that I will be dealing with today are, firstly, whether these arbitral proceedings should be stayed in accordance with the Supreme Court of Philandria's order. Secondly, whether the disputes relating to the validity of the contract is an arbitrable dispute. And thirdly, whether these proceedings should remain confidential or whether there should be disclosure in the public interest. Moving to my first contention, I submit that the arbitration should be stayed in accordance with the Supreme Court of Philandria's order, as this tribunal is seated in Philandria and not in London. Learned arbitrator, there are two clauses that demonstrate where, or that would give an indication of where the seat of the arbitration would lie. First is clause 15.4 of the contract, which states that the arbitration shall take place in London. The next is clause 16 of the contract, which states that this agreement and any other non-contractual obligation arising out of or in connection with this agreement will be governed by the laws of Philandria. Now, learned arbitrators, in the case of Union of India versus Hardy Exploration, a three-judge bench of the Indian Supreme Court held that the usage of the term place cannot ipso facto mean the juridical seat of the arbitration. In light of the same, it cannot be said that London, merely as being named the place of arbitration in this case, would become the seat of the arbitration. In fact, since the parties have chosen for all of their disputes and all of their contractual and non-contractual obligations to be governed by Philandrian law, it must necessarily follow that all the laws applicable to these arbitration proceedings would be Philandrian law. In the case of Enacon India versus Enacon GmbH, the Supreme Court of India held that where there is, all the applicable laws to an arbitration are of one country, it would not be appropriate for the contract to be interpreted as to select a seat other than that jurisdiction. And therefore, such a reference would only be a reference to a venue and not to a seat. And therefore, in this case, it is our submission that Philandria is the seat of the arbitration. All the laws applicable to the arbitration are Philandrian law, and London is only intended to be the venue of the arbitration. Once it is established, learned tribunal, that the seat of the arbitration is in Philandria, this tribunal is bound by the orders of the Supreme Court of Philandria. Under Articles 141 and 144 of the Indian Constitution, the law declared by the Supreme Court is binding upon all courts within the territory of India, as well as all judicial and civil authorities must act in the aid of any order of the Supreme Court. It is my submission that when the Supreme Court passes an order stating that all legal proceedings pertaining to procurement of facial recognition technology must be stayed, within that, it includes this arbitral tribunal's proceedings as well. By using the words pertaining to, the Supreme Court has employed terms of the widest import. In Renu Sagar Power Company versus General Electric, it was held that terms like relating to, in connection with, and in my submission, the term pertaining to as well would be terms of the widest import, and not only would include cases of fresh procurement, but as in this case, procurement of facial recognition technology that is already complete. Therefore, this tribunal is bound by the Supreme Court's order, and it should stay the arbitral proceedings. An additional point to note is that if this tribunal chooses to not stay these proceedings and reaches a determination in an award that runs contrary to any law declared by the Supreme Court in the matter before it, then the award would be unenforceable, as it would violate the public policy of India. And being unenforceable in Philandria, this tribunal is bound, in fact, under Rule 41.2 of the SIAC rules, to pass an award that is enforceable in nature to the best of its ability. And therefore, learned arbitrator, I submit that this tribunal should in fact stay the arbitral proceedings in order to not cause any prejudice to parties by possibly rendering an award which may ultimately be unenforceable or going against the law declared by the Supreme Court of Finlandia.
Mr. Menezes, could I ask you a question, please? Could you expand more on why the award would be unenforceable under public policy, please?
Learned arbitrator, I would simply like to cite the treatise on law of arbitration and conciliation by Justice R.S. Bachawat, in which, when discussing section 48(2)(b) of the Indian Arbitration and Conciliation Act, he writes that an award that conflicts directly against a judicial decision of a court in India would be unenforceable on grounds of public policy. In this case, if the Supreme Court reaches a determination that procurement of such facial recognition technology was illegal and that the government was, or that the NPCC was never entitled to do the same, but this tribunal decides otherwise and comes to a conclusion on damages, that award will ultimately end up being unenforceable as it will go against the law declared by the Supreme Court. Learned arbitrators, I would like to proceed to my next submission, which is deals with the question of arbitrability of this dispute of validity of contract. In the case of Ayyasamy versus Paramasivam, the Supreme Court laid down, in the context of fraud, a two-part working test to determine as to whether a fraud or any illegality would render a dispute non-arbitrable. The first part was that the fraud or the illegality should not touch the arbitration agreement or permeate into the arbitration agreement. And the second aspect was the fraud or illegality should be between the parties inter se and not in the public domain at large. In my submission, learned arbitrators, the illegality in this case is not between the parties inter se and does affect the public domain at large. Now, it can be seen from a government report, an investigative report into the contract, that there are possibly issues of public procurement applicable to this contract, as well as a possibility of corruption in the entry into this contract. My submission is, learned arbitrators, that as far as public procurement is concerned, this is a question for a court of writ jurisdiction and not for an arbitral tribunal. In Center for Public Interest Litigation versus Union of India, or the 2G scam case, the Indian courts held that, the Indian Supreme Court held that when a public authority adopts an opaque and an unfair means for the issuance of a public procurement contract, in such a case that lies in the public interest, and that the court actually has very limited judicial review on the same and must apply constitutional principles when determining whether or not the said procurement was valid. This tribunal, being an arbitral tribunal, will not be competent to enter into these issues of administrative law and of constitutional law to determine whether or not the public procurement is a valid public procurement or not. Nor will it be able to appreciate perhaps the finer aspects of this limited scope of judicial review, which are more in the area of a writ court or within the jurisdiction of a writ court exercising its writ jurisdiction. Learned arbitrator, in light of the same, the issue of public procurement cannot be adjudicated upon by this tribunal. And secondly, as regards the corruption, it is my submission that even the corruption does touch upon the public domain of the arbitration, as the contract in this case is a contract between a public authority and a company, and deals with the purchase of facial recognition technology that is not only affects the lives of billions of citizens, it is also connected to the biometric database containing the personal data of all these citizens. And therefore, an issue of corruption or an issue of illegality in such a contract would massively affect
Sorry, I just want to check it's not just me. I had a interruption there. I missed the last 20 seconds
I
or
did
so.
as well.
apologies, Learner Arbitrator. Perhaps my internet connection cut. Where did I cut off? I could continue from there.
Probably about 15 seconds before.
Learner Arbitrator, just to then perhaps reiterate what my last submission. My submission is that as far as the issue of corruption goes, the corruption as well touches upon the public domain and is not an issue between parties inter se. The corruption in this case is involved in a contract in which it not only deals with facial recognition, which affects the lives of millions of citizens of the country of Philandria, but it also deals in their personal information and personal data, as these drones and this technology is linked to the biometric systems or the biometric data of each and every one of these citizens. Considering the same, this dispute is more appropriately tried by a court of competent jurisdiction rather than an arbitral tribunal. Learned Arbitrator, with that, keeping that in mind, under Rule 29.1 of the SIAC rules, this tribunal may grant an early dismissal of a claim where it manifestly lacks jurisdiction to adjudicate over the same. Now, manifestly, yes, yes,
Counsel, I'm sorry if I can interrupt. Let me clarify. So, please confirm if the dispute that we are entertaining before with my co-arbitrators is a matter of contract. Is that not right?
Yes, Mr. Arbitrator, right. As far as the claims go, it is a matter of contract.
Right. Thank you. Now, the two arguments that you've made proceeds on the premise that the interim order of the Supreme Court, one, is likely or is most likely to be continued to a final order, right? Which will essentially not leave any reason for this arbitral tribunal to adjudicate the disputes that are before us. Second, you're also saying issues of public procurement corruption are not issues which this arbitral tribunal has a jurisdiction over. Now, let me ask the second issue first. Now, this tribunal is not minded to look at issues of corruption and any deviation in the public procurement policy or the rules framed thereunder. That is definitely, as you rightly pointed out, matter for administrative court. The administrative courts may find it proper, improper, that is their domain. But given the fact that both these issues, whether the procurement of facial recognition technology can be procured or not, whether the procurement was proper or not, are issues which the administrative courts will deal with. But today, when I am sitting or we are sitting to entertain and decide on disputes of pure contractual relationships between the parties, is it not a little too presumptuous for us to assume today that the Supreme Court will eventually quash this contract, and therefore on that basis I exclude the parties' ability to exercise the arbitral tribunal as a remedy to resolve the disputes?
Learned Arbitrator, I appreciate the concern with this with respect to the same. However, my submission here is that the lack of the arbitrability of the dispute extends only to the question of validity of the contract, which is a preliminary dispute which has to be decided before actually entering into the questions of whether or not the claims of damages actually stand. Learned Arbitrator, I too have a counterclaim as the respondent that lies against the claimant. However, if it so happens that this tribunal proceeds and does make a determination upon the issues of the contractual claims, only for then another court, an administrative court or a writ court, to come to the conclusion that the contract was never valid in the first place, it would be a waste of these tribunals and as well as the claimant and respondent's time and resources to have gone through this entire arbitral proceeding only for then at a later stage it to be determined that the matter was never that the contract was illegal in the first place. And therefore, the question of validity should first be determined by a court of competent jurisdiction. If it is decided against, if it is decided that the contract is valid, of course, the respondent is happy to come back and have these claims of contract adjudicated upon by an arbitral tribunal. My submission only extends to the question of validity of the contract.
Thank you.
Yeah. So, Mr. Arbitrators, again, moving to the question on on the meaning of the term manifestly under the SIAC rules. In the case of Transglobal versus Jordan, it was interpreted in the context of the ICSID that manifestly would mean plain, obvious, or apparent. And it related not to the seriousness of a rule breached, but to a cognitive process that made that breach apparent. And as the learned arbitrator rightly pointed out, it is apparent and clear that in this case, issues of public procurement and issues of corruption would be more appropriately adjudicated upon by a court of writ jurisdiction or administrative jurisdiction. And therefore, in light of the same, this tribunal should grant the respondent's claim for early dismissal of the dispute. Then, arbitrator, I would like to proceed to my final submissions, which are on the question of confidentiality. Learned arbitrators, firstly, I submit that for the arbitral proceedings to be absolutely confidential, there should have been an express clause outlining the scope of confidentiality as contemplated by the parties. This was the holding of the Australian High Court in SO versus Plowman, and I will deal with the facts of SO versus Plowman in more detail shortly. But the parties could have never had an expectation that their proceedings would be absolutely confidential in the instant case. That is my submission. In fact, when the claimant entered into a contract with a public authority from the state of Philandria, it would have in fact been aware that all of the material and all of its information related to the contract would be subject to the Right to Information Act of 2005, which defines information as to include contracts as well as information relating to a private body that is accessible by a public authority. Under Section 6 of the said Act, any member of the public can make an application for the disclosure of such information that would relate to the contract between ABC GmbH and NPPC. And therefore, the claimant cannot state that it had an expectation that all matters relating to this contract would be confidential. However, I must fairly admit that Rule 39 of the SIAC rules prescribes an obligation of confidentiality upon an arbitration proceeding. However, Rule 39.2E allows a party to make an application before this tribunal to allow for disclosure of materials used in the arbitral proceedings. Now, 39.2E appears to be a residual clause intended to cover situations that are not contemplated in clauses A to D. And in this case, the situation involves one of significant public interest, which would therefore, in my submission, persuade this tribunal to make all the materials relating to the arbitral proceedings public. Learned arbitrators, in the case of SO versus Plowman, the High Court of Australia stated that where the public has a legitimate interest in knowing what transpires in an arbitration, there can be disclosure of the materials used in the said arbitration. In that case, which concerned, I believe, contracts for petroleum, it was observed that the cost that the public would pay for energy would be directly affected by the orders of the, by the proceedings in the arbitration. And therefore, since in light of the same, the public had a legitimate interest in knowing what transpired in the arbitration. In our case, learned arbitrator, there are a large number of factors that would persuade this tribunal to disclose this arbitral proceeding in the public interest. Firstly, the drones are used for facial recognition of citizens. And as submitted earlier, they are connected to the biometric data of all the citizens of Philandria. And a petition regarding the same is also pending before the Supreme Court as to whether or not this is in line with a fundamental right to privacy. Secondly, in the course of performance of this contract, there has been a phishing attack on the respondent servers. And as can be seen, specifically even in paragraph, pardon me, I'll just pull out the correct paragraph. As can be seen in paragraph 21 of the fact sheet, the fact that the NPPC was subject to a phishing attack was a matter of grave public concern, and it was a matter of significant public discussion. And knowing in fact how the cybersecurity was compromised in this case. And thirdly, the investigation by the government into the contract showed issues of possible corruption and public procurement violations. And in light of the same, it is submitted that the tribunal must allow for transparency in this arbitration, as the public has a legitimate interest in knowing as to how such factors have influenced the making of this contract and the arbitral proceedings therein. Learned arbitrators, lastly,
I'm sorry to interrupt you. I'm so sorry, but I just want to ask you a question. If we find that England is in fact the seat of this arbitration, does that have an impact on the issue of confidentiality and the exception that you argue for? Is there any English jurisprudence that may have an impact?
Learned arbitrator, while yes, I understand that there may be a stronger obligation of confidentiality under English law as laid down in cases like Dolling Baker versus Merritt and Hasne Insurance Company versus Israel versus Stuart Mew. However, even under English law, there are exceptions granted where in pursuance of where disclosure is allowed when it is in pursuance of legal rights and obligations, and where there are other reasonable necessities to facilitate or allow such disclosures. And in this case, considering that there is a legal proceeding pending before the Supreme Court, and considering that there is a very large public interest involved concerning nearly every single citizen of the country, there is a reasonable, the requirement for reasonable necessity would be satisfied even if taken under English law.
Thank you for explaining that.
Learned Tribunal, the last case I would like to submit is the one of Commonwealth of Australia versus Cockatoo Dockyard Private Limited, a case before the New South Wales Court of Appeals. In that case as well, it upheld the principles in SO versus Plowman and stated that even where moral, political, or philosophical interests support public access of materials and documents in an arbitration, used in an arbitration, disclosure should be granted. And in light of the facts, as I've submitted before this arbitral tribunal, I submit that there are significant interests in the instant case that would allow for this tribunal to make such a disclosure of all the materials in the arbitral proceedings. If the tribunal has no further questions, I would conclude my submissions.
I don't have any. Thank you.
All right. I'm grateful for the tribunal's time.
Thank you, Speaker. So could I invite the claimant Speaker 1 to make the submissions on the procedural objections raised by the respondent? Claimant Speaker 1.
Hello, I'm so sorry. I got disconnected for a while.
Right.
I've just come back online. Now, members, if I'm clearly audible and visible.
You are. Thank you.
All right. If with your permission, I'll begin with my submissions. Now, members, my name is Abhyuday, and I shall be taking 21 minutes of your time and making 3 submissions pertaining to the procedure of arbitration and the jurisdiction of this tribunal. Now, members, the dispute before you has arisen from a sale of goods transaction, and it is a purely commercial dispute. Now, even despite the pure commercial nature of the dispute, the respondent has tried to paint it as a key public policy matter and relating to public administration to merely put a spanner in the before the proceedings of this tribunal. Therefore, I shall be making 3 submissions, and I'll be mirroring the order in which the respondent has presented them. First, that these proceedings should not be stayed pursuant to the order of the Supreme Court of Philandria. Second, that this dispute should not be dismissed under SIAC Rule 29. And third, that under SIAC Rule 39.1, these proceedings must be kept confidential. Now, before I actually get into my submissions, I would like to differ with my opposing counsel on the matter of the seat and the law of the arbitration agreement. If I may direct the tribunal to page number 10 of the case study, at clause 15.4 of the arbitration agreement. If the tribunal is with me, all right. Now, if you would refer to point 4, where the place of arbitration has clearly been laid out as London, and in point 2, the SIAC rules have been held to apply to this arbitration. Now, SIAC being an international institutional rules would automatically would make this clause a very specific arbitration clause, wherein along with a foreign place of arbitration, a foreign internationally accepted institution rules have been applied to this arbitration, which would render the place of arbitration as the seat of arbitration. The same has also been held by the English High Court in Shashwa versus Sharma, and by the Supreme Court of India in BGS Soma versus NHPC. Further, I would like to point out that the usage by my opposing counsel of Hardy exploration and Enercon versus Enercon was a misapplication. In Enercon versus Enercon, the parties had clearly expressly stated the application of Indian arbitration law. Therefore, the Supreme Court judged that it would be against the party's intention to submit a matters of Indian arbitration law to the courts of England. Therefore, the term place in the contract of Enercon was held to be venue and not seat. Secondly, in the case of Hardy exploration, the parties specifically used the term venue to describe Kuala Lumpur as where the proceedings would actually take place. Since here the exact term venue, now the term venue holds immense importance since it cannot in any since it is unlikely to be construed as a seat of arbitration. While in this specific contract, the word place has been used and has been used in conjugation with the SIAC rules, which will automatically make London the seat of arbitration and not Philandria. Now, secondly, members of the tribunal.
Stop you there, please. The clause over here says that the arbitration shall take place in. It doesn't say the place of arbitration will be London or shall be London. It says it shall take place in. So can you draw me a bit of a distinction there, please?
Now, Madam Arbitrator, with respect to your concern, now since the word place has been used and it's clearly been specified, the arbitration proceedings shall take place in London, which is in a different jurisdiction than the law applicable to the substantive contract. And an international set of rules has been applied. It clearly suggests that the parties have intended that the matters relating to arbitration be governed by a different set of standards than the substantive law as laid down in clause 16. Even though, now I would again...
May I, sorry,
yes,
can I just take that point forward a little bit? We appreciate that the parties to the contract are fairly sophisticated, and I'm sure they would have had sufficient legal advice while entering into the contract. The usage of the word shall take place in London, and I'm speaking for myself here, definitely to my mind refers to only the place. Had this been a choice of seat, parties could have said that. Number one. Number two, even if you apply the Supreme Court of India's judgments, which your learned opposing counsel has referred, which says the governing law of the contract is, in this particular case, laws of Philandria, would I not be right in at least assuming, even if I'm not saying to the extent that Philandria should not be the place of arbitration, but at least one can come to an argument or come to a conclusion that the intention of the parties is at least not clear, because the clause as such is ambiguous. See, if you look at the clause in the contract, in clause 16, it says, shall be governed by and construed in accordance with the law of Philandria. 15.4 says shall take place in London, and then it says shall be in accordance with SIAC rules. Now, SIAC rules and London do not have a direct relationship, right? SIAC is from Singapore. Obviously, you can apply SIAC rules anywhere in the world, but at least the contract shows me 3 different places or refers me to 3 different places. One could be Singapore because of SIAC rules. The other is the applicable of Philandria, so therefore Philandria, and the place of arbitration, London. So will I not be, why should I not be tempted to say that the construction of seat governing law at least gives me a feeling that the contractual provisions to determine the seat is ambiguous?
All right, Mr. Arbitrator, to answer your concerns, I would like to base my answer on commercial sensitivity and the practice usually prevalent in international commercial arbitration. If that be all right, my first point would be that as was also agreed by the High Court in English High Court in Shashva versus Sharma, that the London arbitration clause and the belief in the international arbitration community upon the arbitration laws of England make the London arbitration clause a very popular choice to actually refer and render disputes under the jurisdiction of those courts in England. Secondly, since the respondent is a state party, Mr. Arbitrator, and this is a public procurement contract, it would have been in the intention of my client and of course the respondent to submit this dispute to a quote unquote neutral jurisdiction wherein there would have been no effect or even a subconscious impact upon the rulings of the arbitration court. Therefore, those 2 particular factors, when considered, make the case for the London seat stronger.
Perhaps you could have made your intention of a neutral venue clearer while you were drafting the contract. Not having done so leads me to a feeling that you never wanted that.
Mr. Arbitrator, respectfully, I would like to submit that while this contract would have been drafted, it's in 2019, the parties and their counsels would have been aware of the judgments in Shashva versus Sharma and BGS Soma. So the very purpose of actually laying down the arbitration clause in the exact manner as has been laid down in those judgments would actually point towards the parties following those judgments to the T and determining London as a seat of arbitration.
Thank you.
Thank you. Now,
Mr. Singh, I know you have several more issues to go to in a limited period of time, and the tribunal is really parsing language with you right now, but I'm going to continue to do that for just a moment. And my question on the language in 15.4 actually goes to the word before the phrase that Mr. Schenk was addressing, and that is that it says the arbitration shall take place in London, England. It doesn't say the hearing, it doesn't say the proceedings. Is there any significance to the use of the word arbitration versus hearing or proceedings or some other word?
Mr. Arbitrator, if the word hearing had been used, then that would have pointed towards the opposite direction, as merely the hearings were being conducted in the physical place that is London. While the word arbitration itself is a broader term, is a more legal term, in that the parties have intended the arbitration itself to take place in London. Further, I would also like to point the tribunal to further substantiate my claim to Procedural Order 1, Annexure number 2. In the last in the point 7 on page number 13 of the procedural order, the oral hearings were clearly separated from the place of arbitration in this case as to be Bangalore, India. So while the parties might have intended and have intended London to be the seat of arbitration, they simultaneously left it to the tribunal to determine the venue, which was determined by the tribunal to be Bangalore, India, for whatever reason the tribunal might have had. So since there is a distinction. And since, if you would note, in point 7, the word oral hearings has been used instead of arbitration. While in clause 15.4, the word arbitration has been used so as to import the entire meaning of the word arbitration to London. If the tribunal is satisfied, if I may move to my next submission. Thank you.
Thank you.
Now, if the tribunal agrees with my submission that London is in fact the seat of arbitration, using the law as laid down by the Court of Appeal in Enka versus Chubb, the law of the arbitration agreement would be synonymous with the curial law that has been applied by the parties. Therefore, this arbitration would have no application of Philandrian law can be validly made before this tribunal, since it is not subject to Philandrian laws. Now, with respect to the second submission, with respect to the first submission that the respondent made, now the Supreme Court order, if the Supreme Court order is fundamentally outside of its jurisdiction, since the courts at the seat have the exclusive supervisory jurisdiction over this tribunal. Since Philandria, as I've already pointed out, is not the seat of arbitration, no court in Philandria holds binding power over the tribunal. Now, secondly, even if the tribunal were to disagree with my assertion of London as being the seat of arbitration, I would like to point the tribunal to the decision of the ICC tribunal in Saipem versus Petro Bangla, wherein despite a specific anti-arbitration injunction from the Dhaka High Court, the ICC tribunal continued proceedings because of its reasons, as I'll point out, and it directly applies to this case as well, that the primary duty of the tribunal was to resolve the dispute between the parties and not to pay primary dispute was to resolve the dispute between the parties and carry on with its resolution, while the stay order would have stopped the arbitration proceedings and not let it continue with its primary purpose. Now, thirdly, Mr. Arbitrator, regarding the respondent's claims of unenforceability, I would like to point to the tribunal that under section 48, clause 48(2)(b) of the Arbitration Conciliation Act of Philandria, an award can only be refused enforcement if its enforcement violates the public policy of India. Now, since the enforcement of this award will only involve the transfer of monies between one party to the other, even if the tribunal were to differ with on the matter and on fundamental rights from the Supreme Court, the enforcement of its award will not lead to infringement of fundamental rights, since the enforcement of the award will not require any other action than a mere payment of a sum. Now, if the tribunal is satisfied with my submissions on this issue, if I may move to the next one. Now, with respect to inarbitrability, I would like to point out that since the respondent is approaching the tribunal under SIAC Rule 29, the burden of proof upon the respondent is a manifest standard. It's very high. The respondent has to make a claim which will leave no doubt as to the jurisdiction of the tribunal, because it is asking for dismissal of the dispute in a mere 60 days, which is a very little time. Now, further, I would like to point the tribunal again to the reliefs that have been asked by the parties. The parties have asked the reliefs of claims
Mr. Singh is frozen up on my screen.
Same here.
Likewise.
Same here.
Mr. Singh,
I'm extremely sorry, tribunal. He's having some connectivity issues. He's trying to connect back. He'll be back in a minute.
Yeah, I will just pause the time. I think he's connected back. I will perhaps give him a 30 seconds to gather his breath.
Thank you. Where did the tribunal lose me exactly?
You were talking about the relief being sought.
All right, thank you. Now, the tribunal's award is unlikely to interfere with any court's jurisdiction on any phalangian court's jurisdiction with respect to the any supposed allegations of corruption that have been made, because the award will only pertain to the claims that have been made under the contract, which are purely commercial, which are purely based upon whether payment was validly made or whether the goods were of satisfactory condition. Now, since this issue cannot validly interfere with the jurisdiction of any court trying the specific persons or trying the respondent for matters of corruption or the violation of public procurement legislation, since they are merely claims under this contract, and their enforcement will merely be an in personam enforcement by the arbitrating parties against each other and not against the world at large.
Mr. Singh, first of all, I don't think the tribunal has much clarity. In fact, I don't think the parties have much clarity on what the specific allegations of corruption are. But isn't it the case that if there were in fact some acts of corruption, conceivably the contract itself could be invalid? Is that the case?
Mr. Arbitrator, even if there was corruption even if there was corruption in the formation of the contract, this dispute would still be arbitrable following the decision of the Court of Appeal in Fiona Trust versus Privilov, wherein the mere allegation of bribery does not oust the dispute from the jurisdiction of the tribunal. Now, since mere allegations have been made, and even if the contract were to be rendered void by the action of bribery or corruption, this would not affect the arbitration agreement because the arbitration agreement cannot automatically become void as a law at like the same time as the underlying contract becomes void. It is a separate agreement for that respect. Since no actual ground has been laid down by the respondent, which would affect both the underlying contract and the arbitration agreement shall stay valid even though the contract is declared to be void.
Thank you.
Arbitrator. Now further, if I may continue on the issue of corruption, I would like to point the tribunal to the decision of the Supreme Court of India in Swiss Timing versus Organizing Committee of the Commonwealth Games, wherein the Supreme Court has reached a similar decision as to the mere allegation of fraud or corruption in the transaction cannot actually oust the jurisdiction of an arbitral tribunal. Further, now,
Mr. Singh, are you alleging or is the allegation that this contract was entered into by fraud?
That is what the allegations seem to come out from the respondents' submissions, Mr. Arbitrator, yes.
Right. How do you respond to that submission? Because that is intricately linked with Swiss Timing's judgment that we're just about to discuss.
Yes, Mr. Arbitrator. Now, since now they've alleged that in the formation of the contract, the public procurement laws were not followed, and my client was given preferential treatment of some sort while entering into this contract. This, as is according to the respondent, evident from the repeated visits of NPPC officials in the state that was posted. However, this does not actually point towards legitimate claims of corruption. And the matter of public procurement is anyway a matter to be determined by the tribunal or by a specific court in the merits, on merits. And the mere introduction of such a claim will not void the jurisdiction of the tribunal to try contractual claims.
Thank you.
Thank you, Mr. Arbitrator. Now, if I may, now further, with respect to fraud, there is no allegation of criminal fraud on either of the parties in this case, members of the tribunal should note. And even if there was, the fraud is merely with respect to a misappropriation of funds. And such a fraud has been held to be perfectly applicable even by the Supreme Court judgment in Ayyaswamy versus Parveswaram, where Now, I seem to be running out of time, members. If I may request for a 2-minute extension to complete my issues.
That's certainly fine by me.
I agree.
Yes, and me too. Yep.
Absolutely.
Thank you. So, therefore, the mere allegation of a misappropriation of funds and would not oust the jurisdiction of this tribunal. Now, coming to my last issue with respect to confidentiality, if the tribunal was to accept my submissions as per the seat, there is an implied obligation of confidentiality under English law, which can only be voided in public interest if the public interest demanding the release of such information outweighs the loss that would be caused to my client. Now, if I may point the tribunal again to paragraph number 6 of the case study. Members, is the tribunal with me? Now, in paragraph number 6, the first 3 lines, it has been clearly stated that facial recognition technology at this stage is a very nascent technology, and my client is one of the few companies globally to actually possess the expertise to A, produce such a technology on a commercial level, and B, to integrate it with drones. So if this information, this ability provides my client with a great amount of commercial exclusivity, which would be lost if these documents were to be released to the public, causing almost irreparable harm to my client. Now, on top of that, if the tribunal were to turn to annexure number 5 of the case study, the report of Milloyd Consulting.
When you say irreparable harm, can you just elaborate on what kind of harm you think is going to be caused to your client?
Yes, of course, Madam Arbitrator. The harm that would be caused would be incapable of being predicted or being repaired via damages. It would be inherently unquantifiable, because my client would lose its commercial advantage and would open up the market to newer competitors who would have not been in the market, who would have only been allowed to enter the market because my client's technology and the details regarding my client's technology were released to the public.
And sorry, can I just ask Mr. Singh, so is it your submission that if the submissions, pleadings, hearing and evidence relating to this arbitration are released, that is going to cause irreparable harm because it involves your technology? Because that's not my sense so far from the submissions we've seen so far, that technological information is actually contained in these documents.
Now, Madam Arbitrator, now, yes, although that is true that exact technological details have not been contained in the evidence that has been submitted to the tribunal. However, my co-counsel will be making arguments pertaining to the limits of the technology. So that will automatically render, disseminate information as to the capabilities of the technology that we have produced and how we've actually done that, and what can be done to improve or to sabotage such technology.
Do you think some parts could be redacted?
Now, Madam Arbitrator, before I answer this question, is the tribunal, I would like to ask for a minute and a half more of extra time, if that is all right. Okay. Now, if such things were to be redacted, Madam Arbitrator, that would be no different from any general paper on facial recognition technology, since the specifics of my client's facial recognition technology are what actually makes them unique. So if the specifics were to be actually redacted, there would be no practicable difference between my client's specific technology and any general paper or any generally acceptable parameters of facial recognition technology. So if the Supreme Court, and further, Madam Arbitrator, now, if you are satisfied with my answer, may I proceed further with my submission? Thank you. Now, If further, if as I've already pointed the tribunal to annexure number 5, the report of Minoid Consulting, as it relates and lays out my client's e-security network infrastructure. If this were to be released along with my client losing its commercial sensitivity, it would also be more susceptible to e-attack, which would further the strain upon my client. Now, further, members of the tribunal, I would like to counter the argument that has been made by the respondent under SEAC Rule 39.2 Clause C. I mean, Clause C, have I lost the tribunal? Am I online? All right, thank you. Under Clause C, a right has been given to avoid confidentiality on the condition that a right or claim needs to be defended or enforced before a court. However, the respondent is not a party before the Supreme Court proceedings as of yet, since their actions are not subject to the petition before the Supreme Court. If the tribunal would refer, since the action which actually led to the petitions before the Supreme Court were caused by the Philandrian police and not by the respondent itself, the contract and the details regarding its procurement are not under scrutiny by the Supreme Court. Rather, the action of the Philandrian police is. So there is no legitimate chance that the respondent can actually claim before the Supreme Court or defend a right in a proceedings that it is not even a party to. Now, lastly, I'll just take 30 more seconds of the tribunal's time. Now, if the tribunal were to reject my argument as the seat and set the seat as Philandria, Section 42A of the Philandrian Arbitration Conciliation Act imposes a mandatory duty of confidentiality, which cannot be avoided in any circumstances before the enforcement of the award or the challenge of the award. So that would automatically stop the respondent from avoiding confidentiality. Now, just to conclude and summarize, I've laid down 3 things before the tribunal. A, that this dispute should not be dismissed as per SEAC Rule 29. These arbitration proceedings should continue and confidentiality must not be voided. I thank the tribunal for its time.
Mr. Singh, if I could ask you one more question, and I think this time should go to the tribunal, not be taken away from you. One question that's been on my mind that I think touches on some of these issues that you've been discussing, and if your colleague is planning to address this later, let me know. But my question is, does the Philandria Public Procurement Act, found in Annexure 6, even apply to this situation?
All right. With respect to your concern, Mr. Arbitrator, actually, I would like to argue that in this situation, the Philandrian Act, this situation perfectly comes under Section 7, under exceptions given under Section 7 of the Act. If the tribunal were to refer to the last annexure, just the last annexure is, if the tribunal is with me at this page.
Yeah, that's page 27, right?
Yeah, yes. Under 7 subclause A, it is clearly stated that during a natural calamity or emergency, the provisions of this act can be ignored and a tender process is not mandated. Then I would like to refer the tribunal to paragraph 4 of the case study on page number 2. The tribunal is with me at this point. In paragraph 4, the first 2 lines clearly state that there was growing discontentment that had led a significant portion of the populace to take to the streets to protest, and rallies had been organized across the country. The police force has found itself under enormous pressure to control the situation, and to make matters worse, the protests were turning violent. Now, since there was, and this creates a situation of emergency which would have allowed the respondent to actually surpass the tender process, since there were violent protests from a significant portion of the population across the country. So this would have been valid procurement even under Philandrian law.
Do we know from the factual record if any formal state of emergency had been declared?
No, Mr. Arbitrator, although a formal constitutional emergency had not been declared, but I would like to point the tribunal again to the language of Section 7. The language of Section 7 does not refer to a constitutionally mandated period of emergency, but rather a natural calamity or emergency. So it is clear from the language of Section 7 subclause A that the duty, the standard as to what is emergency is very different from a constitutional or an official state of emergency in this case.
Okay, thank you.
Just one thing, is there any precedent that you can rely on which equates law and order issues as the same as emergency? Because emergency in clause 7 is parimateria, with the other term is calamity, right? So calamity is the parimateria word used in subsection A of 7. But what the fact sheet says is a law and order issue. At this point in time, it's intermittent across the country with a possibility of it having spread across the country. Now, any precedent that you can rely on to show that they're the same things?
Mr. Arbitrator, with respect to your question, I apologize. I do not have any precedent to present before the tribunal at this point. However, I would like to point out that since the laws of Philandria are in pari-materia with the laws of India, in this case, I would not be able to rely on Indian law to make my case strong, since India does not have a Public Procurement Act. Rather, its public procurement is governed by the general financial rules set out by the Ministry of Finance. This particular legislation is a unique turn in Philandrian law and is different from Indian jurisprudence. Therefore, I apologize, I will not be able to present any judicial precedent as to this. I am terribly sorry.
Thank you, Mr. Singh, for your candor.
If the tribunal, if I may be of further assistance, or I thank the tribunal for its time otherwise.
Thank you.
Thank you.
Thank you.
I invite the claimant to speaker to continue the submissions on behalf of the claimant and argue on the merits of the case.
Thank you. Am I audible and clearly visible? Thank you.
Yes, Lord. Thank you.
Good evening, members of the tribunal and opposing counsels. My name is Unni, and I shall be dealing with the merits of the case on behalf of the claimant, ABC GmbH. I shall be speaking for 21 minutes and will be reserving 1 minute for rebuttals. Our client, ABC GmbH, is a company with a proven track record of deploying their drones to law enforcement agencies in various countries. The contract entered between the parties stipulates that the respondent is supposed to initiate payment within 12 days of confirmation of dispatch. However, they have failed to honor their commitment towards my client, pushing us into extreme financial stress. The respondent was negligent throughout the transaction, aiding to the success of the phishing attack and the loss of 40 million euros. The drones successfully controlled the protests in Philandria, but the respondent has tainted my client's image and reputation by alleging that the drones were defective. Contrary to the allegations, the drones were extremely effective, and the incident at New Riley was a remote one owing to exceptional circumstances. Therefore, I'd like to advance two main submissions on behalf of the claimant. One, respondent is in breach of clauses 31B, 31C, and 31D of the agreement, which are related to the payment for the first 3 tranches of drones. Members of the tribunal, these clauses are mentioned in page 9 of the case study as a part of Annexure 1. 2, claimant is not in breach of clause 1 of the agreement. Moving on to my first submission, I'd like to break the argument further down into two limbs. One, payments under clause 3.1b and c, which are linked to the phishing attack, and two, payments under clause 3.1d of the agreement. I shall proceed with the first limb and then move on to clause 3.1d. An unfortunate phishing attack occurred where an imposter gained unauthorized access and sent fraudulent wire instructions through emails with spoofed domains to the respondent. As a result of this, the respondent wrongly transferred the payments under subclauses B and C to a bank account based in Liberia after following instructions sent by the fraudster. The pertinent question that arises now is that who will be held liable for the losses of the phishing attack? In St. Lawrence Testing and Co. versus Lanark Gleats Distribution, it was held that in case of a phishing attack, the secondary victim, in this case the respondent company, will be held liable, and only under three exceptions can the initial victim, that is my client, be held liable. Before moving on to the exceptions, I'd like to make a quick note on the applicability of the case St. Lawrence. St. Lawrence is a Canadian case law. It adds persuasive value because Philandrian jurisprudence relating to phishing attack is still at a rudimentary stage. Hence, I'm using a foreign case law to call out the general principle adopted when a phishing attack happens. Now I shall go ahead and prove how none of these exceptions are applicable in the current scenario. The first exception is when the parties have agreed to shift the liability of the loss resulting from fraudulent payment instructions to the initial victim, that is my client. However, this was not done in the current case. The second exception is that there is evidence of willful misconduct or dishonesty on the claimant's part during the persistence of the contract. Our client has always exhibited good faith towards the respondent. Members of the tribunal, if you may turn your attention towards paragraph 12 of the case study, given in page 4, if the tribunal is with me. Am I audible? Yeah. If you're with me, we can see that ABC officials personally flew down to acquaint NPPC officials of the working of the drones and were always ready to help out in case of any difficulties. At no juncture during the dealings did our client proceed with dishonesty and willful misconduct. This brings us to the third exception, which is regarding the negligence on part of the claimant. Our client has a multi-stage mail security check, which is elaborated in Annexure 5 of the case study. Members, you can find this in page 25. If you're with me. Yes. The system that we have put in place, which is elaborated from point 2 to 5 of the Malloy Consulting Report, shows how we maintained a sophisticated security system with a 3-stage vetting process. The system was in line with contemporary practices employed by corporates to prevent cyber attacks. Now, the respondent might allege that a security system lacked an email validation feature. However, members of the tribunal, if you look at the second line of point 8 in Annexure 5, it is mentioned that my client has employed the HELO filter, RDNS check, and SPF check, which are potent substitutions for the email validation feature. Hence, it is extremely unreasonable to hold the claimant liable for not having a completely foolproof system, which is almost impossible to achieve. The question here is whether my client was negligent or not, but the sophisticated security system definitely surpasses the standard of negligence. What is even more important in the current scenario is the subsequent negligent acts of the respondent post the initial attack, which actually made the attack successful. I shall list them out one by one so that the tribunal can take cognizance of them. If the tribunal can draw their attention to page 18 of the case study, it shows the initial, if the tribunal is with me, it shows the initial mail sent to Lakshmi Chakma, the responding company's financial officer. even though the mail was from the correct domain of the company, it still had the spoofed email ID CC'd in it, if you can see that. This clearly shows that Ms. Lakshmi Chakma failed to take cognizance of that. Further, all the subsequent emails on this thread were sent from the spoof domain abc-tech.fe, which the respondent failed to take cognizance of. Members of the tribunal, it is interesting to note that Ms. Chakma was so negligent that she failed to identify the difference between the domain names of the spoofed mail she received from Dwight Schrute on 9th October. This can be found in page 16. And the domain name of the actual mail sent by the real Dwight Schrute on 10th of October, page 22. Can be found in page 22, members of the tribunal.
Mr. Krishna, if I can just jump in there. I mean, we're talking about a simple dash in the email address. Is it really fair to say they were extremely negligent? I think that's the word you used, for overlooking a dash in the middle of an email address.
Mr. Arbitrator, I understand your concern, but this is just one of the negligent acts listed down by Ms. Chakma. I shall proceed to show how there were a lot of subsequent acts wherein she could have exercised minimum standard of care and averted the loss of 40 million euros. Proceeding to that, if the tribunal may draw their attention to the specific mail sent on 9th October, again given on page 16, it can be observed that Ms. Chakma failed to notice that the signatures under the mail sent from the spoof domain lacked easily discernible parameters, namely the phone number, email address, website, confidentiality footer, and she completely failed to take cognizance of all that. And also, she failed to exercise care and caution because a mere inquiry through call could have averted the loss of 40 million euros. She failed to verify the authenticity of the Chamber of Commerce letter and sanctioned the payment recklessly. Also, Ms. Chakma was grossly negligent in following up on the transaction as well. She failed to CC other officials at ABC, even though she was aware of Schrute's absence from office, as Dwight Schrute had pointed it out specifically in his mail sent on 10th October, given in page 22 of the case study. In fact, in that mail, Schrute had urged her to contact other officials. This would have helped in other officials of ABC alerting MPPC of a possible cyber attack, and the whole predicament could have been averted as a wire transaction could be reversed within 2 days of instruction. Mr. Arbitrator, I hope that this has clarified your query as to how Ms. Chakma was not just negligent in noticing the small dash, but there were a lot of subsequent acts that Chakma could have easily identified to prevent the phishing attack from being successful.
So you think that perhaps she could have given a call? Is that what you're saying, rather than just relying upon an email?
Yes, ma'am, arbitrator. This is because you see the situation has clearly changed. The transaction is of 40 million euros and the bank instructions have changed. There are suspicious domain names in question. There has been no communication regarding the bank account on the mail sent by on 10th October by the actual Dwight Schrute. In such a suspicious circumstance, picking up the phone and making a call to my client would have clearly averted the entire crisis.
And you also mentioned that she could have checked about the letterhead, the letter that came from the International Chamber of Commerce. How would she have checked that? How would you have done that? What would you have done?
Yes, ma'am, arbitrator. Ma'am, arbitrator, if I can take you to the letter from the Chamber of Commerce, which is given as a part of Annexure 4 in page 24 of the case study, you can see that there is no official seal from the Iberian Chamber of Commerce in that. The signature is not there. It is just written SD. And in that case, a financial officer should at least have the basic prudence to understand that, see, this letter clearly lacks a lot of things that in a normal circumstance it would have had. That is why she failed to take. She should have checked the authenticity of the letter by calling up the claimant company. That is what I'm trying to say, ma'am, arbitrator.
Mr. Counsel, can I ask you a question, or rather a clarification? Are you simply contending that the counterparty was grossly negligent, or are you also going ahead and saying us that she was perhaps collusively acting with the third party interloper in making the payment to the third party entity?
Mr. Arbitrator, to answer your question, what I'm trying to say now is that the negligence was can be completely attributed to the respondent company and its officials. Thereby, the liability of the loss arising from the phishing attack should be undertaken by the respondent company.
So you're simply saying it's a negligent act. It's not a deliberate collusive act by the counterparty.
Mr. Arbitrator, at this point, without further investigation, we can't really understand whether there was any foul play involved. However, the general principle followed in case of phishing attacks is the loss is assigned to the person who has been negligent during the transaction.
Thank you.
Thank you. Moving on.
Mr. Christian, just to pick up, I just want to clarify, what exactly is the standard? Is it negligence or is it higher? Is it gross negligence? Because you've been using, I think, some of these adjectives, grossly negligent, extremely negligent. What is the standard that needs to be met here?
Mr. Arbitrator, the standard is negligence. The usage of grossly negligent was because of the acts that Ms. Chakma did, which warranted the usage of grossly, because even a normal human being can understand that if the same person is contacting her from email addresses that have different domain names, there is something suspicious. It was just to increase the... moving on to the payment under clause 31D. Our client delivered the third tranche of drones, even though the payment for the first two tranches was not made. I'd like to present two main claims to substantiate our stance. One, question 45 of the clarifications list mentions that the third tranche was delivered to NPPC, but they refused to accept delivery. Hence, the respondent is liable under Section 31 of the Sale of Goods Act, which mandates the buyer to accept and pay for the delivered goods according to the contract. Second, the court order passed on October 24, 2019. If you can, this particular court order is given as part of paragraph 26 in the case study. The language of the court order has stayed only the legal proceedings pertaining to the procurement and not the procurement itself. Payment cannot be classified as a legal proceeding. It is merely an integral part of the contract. Therefore, the respondent has not honored their promise of payment under the contract and are in breach of its obligations under clause 31D. I'd like to move on to my next submission that the claimant was not in breach of clause 1 of the agreement. There were two rules under clause 1 and claimant has complied to both of them. I shall henceforth explain the same. Before continuing, members of the tribunal, this clause can be found in page 9 of the case study as a part of Annexure 1. So Rule 1 says that each drone unit should be tested. The claimant has indeed tested each drone unit before its dispatch. If I may direct the attention of the tribunal to question 21 of the clarifications list, the tribunal is with me. It is clearly mentioned that all the drones were indeed tested before dispatch. Hence, the claimant has clearly not violated Rule 1 of Clause 1. Now, moving on to Rule 2, the goods supplied by the claimant were fit for purpose. I shall demonstrate the same through three arguments. One, the purpose of the contract was fulfilled. The object of the contract was to identify fringe elements that were turning the protests in Philandria violent and to control these protests. This was accomplished through the usage of drones, as it is clearly said in the case study in paragraph 23, that the respondent was able to control the violent protests in various locations across their country. This proves that the drones had corresponded with its description and had fulfilled their purpose. Ma'am Arbitrator, the very fact that the drones were largely successful is given in page 23, 6th line from the board. Yeah. Moving on to my next submission, the second argument is that Rule 2 was not violated by the claimant, as the incident in New Riley was a remote exception owing to abnormal conditions. The drones malfunctioned in New Riley because the PM 2.5 levels were prohibitively high. Drawing parallels from the PM 2.5 levels in capital cities of countries sharing geographical proximity to Philandria, like Delhi and Dhaka, they had PM 2.5 levels of 200 and 146 respectively in the 2019 winter season. These numbers are not even close to the PM 2.5 levels, which the drones were expected to accommodate, which exceeded 1,000. Any level above 300 is termed as hazardous, and people are advised against outdoor exertion. Hence, it is very unreasonable to expect drones to function at such high PM levels when people are not even allowed to be outside, let alone protest. The third argument is that there was no implied condition as to the quality or fitness of drones.
Could
Now,
I
if we look,
stop you there?
yes, ma'am,
Just on your previous point that you were making, I know that there were meetings before the contract was signed and there were several discussions. Given that the pollution level is such an important part, was that under discussion at all? Was anything explained? Did this topic come up at all?
Ma'am arbitrator, in fact, the respondent company had reached out to us with a specific set of requirements. And in a mail sent by my client CEO, which is given in page 15 of the case study, we had proposed that TRC 2645 would definitely meet all their requirements, and this is very evident from the fact that the protests have been controlled successfully. However, we believe that there was no discussion regarding the exorbitantly high PM 2.5 levels in New Riley. And we believe that in this case, the buyer was supposed to let us know about this abnormal condition that was existing in their in New Riley.
Why do you believe the buyer should have been telling you? Did you ask any of the questions given that you were supplying the product?
Ma'am arbitrator, to answer your question, I have 2 points. The first one would be the buyer in this case never relied on the skill and expertise of my client to make drones that work in such high PM levels. It had not enabled the claimant with enough information to exercise the skill and judgment to select goods which will work in such abnormal pollution levels. Also, it is very important to observe the existence of an esoteric purpose here. According to section 14.3 of the English Sale of Goods law, highlights the degree of disclosure a buyer has to make to invoke the seller's responsibility if an esoteric purpose exists. The esoteric purpose in question is the knowledge the respondent possessed about the places where they will deploy the drones and when they will do so. When NPPC, but before I continue with my argument, I'm running out of time. So if I can get an extension of 2 minutes, I'll quickly sum up after giving the answer to this question. So when NPPC asked the claimants for drones, it also had to elaborate on the locations in which these drones were to be used. Now, to buttress my submission with the authority, in Griffiths versus Peter Conway Limited, the position held was that when the goods are generally fit for a particular purpose, but do not suit a particular case because of some abnormality with it, the seller cannot be held liable for breach as the buyer has failed to disclose adequate information about the peculiar conditions. The drones were reasonably fit, evident from its effective functioning in every other city in Philandria. It was just the abnormal conditions of New Riley that the drones failed to. If I've answered your query, ma'am arbitrator, can I proceed with my process?
Mr. Counsel, could you not have contemplated that the drone could actually also be deployed at the most polluted city in the country of Philandria?
Mr. Arbitrator,
was that not a reasonable expectation that a buyer would have from a specialized manufacturer of such drone?
Mr. Arbitrator, to answer your question, yes, we made drones when they gave out certain requirements to us, and the drones were effectively functioning in every other part in Philandria. So like I had mentioned earlier, with respect to New Riley, 1,000 is a PM 2.5 level that has never occurred before. Because even in Delhi during last winter season, The maximum it went up to was around 500. What we are talking about here is 1,000, which is beyond the expectations of any company, especially that we are a company based in Europe and are not very well aware of the situations in Asia and the topographical conditions in Philandria. If I've answered your query, Mr. Arbitrator.
Yes, please go ahead.
Yeah. Now to just conclude, the respondent cannot even allege that the goods did not correspond with the sample, as we had given them the opportunity to test these drones either in Philandria or in Switzerland. However, respondent decided to test these drones in Switzerland, which is not the actual locations where the drones were going to be used. Therefore, respondent passed on the opportunity of reasonable examination in Philandrian conditions. From the aforementioned arguments, it is clear that the claimant has not breached Rule 2 of Clause 1. Further, we have been prompt in our delivery and honored the deadlines set in the contract, while the opposing party has not even made the payment for the first tranche. NPPC has breached the subclauses B, C, and D of Clause 3 and has arbitrarily cancelled all the remaining orders. As a result of this, the claimant submits that the respondent is in breach of its payment obligations in the contract and the claimant has not breached Clause 1 of the agreement. If there are no further queries, I'd like to end my submission here. Thank you.
Thank you for your submissions, claimant speaker. I would now request the respondent speaker number 2 to address the arguments of the claimants.
Thank you. Good evening, Learned Tribunal. Am I audible?
Yes, thank you.
Thank you so much. Good evening. I am Priyanshi Vakharia, and I am the second speaker on behalf of the respondent submitting arguments before the Learned Tribunal on the issues of the claim and the counterclaim. I will be tackling the alleged breach of clauses 3(1)(b) and C together, following which I will be dealing with the breach of clause 3(1)(d) and the claimant's breach of clause 1 of the contract. When dealing with the non-payment under clauses 3(1)(b) and C, I submit to the tribunal a three-pronged approach in law. The respondents set out to make the payment under clauses 3(1)(b) and C in good faith and in a timely manner. Unfortunately, these payments have been intercepted by way of a phishing attack. As a result, it is the respondent's first submission that a phishing attack is a force majeure event under clause 10 of the contract to be found at annexure 1 of the case study. The second submission that I lay before the Learned Tribunal is by placing reliance on certain cases of the Canadian courts which deal directly with the circumstance of a phishing scam or a business email fraud, which relates to the facts of the present case. And thirdly, time permitting, I look at the principles of the UPICC, or the Principles on International Commercial Contracts, by the UNIDROIT, of which India, and by extension the state of Philandria, has been a member of since the year 1950. Would the tribunal have a preference in which of these three prongs I address first? Thank you. Learned Tribunal, allow me to begin with the force majeure submission, and I place reliance on Indian and English jurisprudence for this purpose. Clause 10 of the contract states as follows, and I reiterate for the tribunal's benefit: neither party shall be in breach of this agreement, nor liable for delay in performing or failure to perform any of its obligations under this agreement if it is prevented or delayed in performing those obligations by an event of force majeure or by events beyond its reasonable control. The respondents submit that despite exercising due diligence and reasonable care, they could not have prevented or anticipated a phishing attack. We rely on the cases of Dhanraj Ram Gobind Ram versus Shyamji Kalidas and Company, which is a Indian Supreme Court case, which held that the intention of a force majeure clause is to save the performing party from the consequences of anything over which it has no control. The court acknowledged that the widest possible meaning was to be given to a force majeure clause, something that was reiterated, or if I may use the word chronologically, something that was borrowed from the case of Odal Trading Company Limited versus Francois Tager, an English case, which held that a force majeure clause must be construed in each case with due regard to the nature and general terms of the contract. And this is relevant because understandably, the contract does not particularly mention phishing attacks as a force majeure event. Now, I submitted shortly earlier that the respondents have exercised due care and reasonable diligence. And if I may take the learned tribunal to the relevant facts in the case study, the email that was sent on 9th October at 8:15 a.m. to Ms. Chakma, which the tribunal may find on page 18 of Annexure 3, was sent by the legitimate account of Ms. Jenny Liu. In the forensic report in Annexure 5, we find that the hackers had gained unauthorized access to Ms. Liu's account. My learned friends on the other side have raised certain concerns, wherein they're worried that Ms. Chakma was unable to notice certain discrepancies in the domain name and in the signatures, to which I submit, learned tribunal, that the discrepancy in the domain name existed in the CC'd addresses, which is not generally something that the receiver of an email might check. Similarly, they also raised the concern that the discrepancies in the signatures were not spotted. But by the discrepancies, if I may submit, exist in the missing phone number, website, and email ID of the sendee, and not in the general signature present. So if I may direct you, for instance, if I may just take a moment to pull out Annexure 3, and if I look at any email that is sent from the claimants, what you will find is the name of the sender, their designation, the company name ABC GmbH followed by the address of the company, and then the phone number and email ID of the sender, as well as the website of the company. Now, if I may invite your attention to the hacked emails or the compromised emails, these emails still have the name of the sender, their designation, and the company address, and it is the last three legs of the signature that are really missing. Nevertheless, Ms. Chakma has exercised due diligence by contacting the Liberian Chamber of Commerce for a letter confirming the relationship between the claimant company and its apparent subsidiary. Now, my learned friends on the—
Can I stop you there?
Absolutely.
She didn't contact the Chamber of Commerce, did she?
And learned arbitrator, she contacted the supposed hackers who she believed to be were the claimants, who then ended up intercepting and forging a letter from the Liberian Chamber of Commerce. But the letter which was couriered to her did come from Liberia. As a result, the letter which was also sent to her via email was also on the letterhead of the Liberian Chamber of Commerce. So when my learned friends contest—
But it also just said SD for signature.
Absolutely, absolutely, learned arbitrator. And this is precisely what—
Would that have twigged anything in a person's mind, particularly if you're in the finance section?
Thank you for your question, learned arbitrator. And this is precisely what I wished to address, that this concern about the letter not being signed and the letter not having the stamp of the Liberian Chamber of Commerce exhibits a degree of extreme care that's not necessary for Ms. Chakma to exhibit in the present case. And the reason I submit this to you is by placing reliance on the Canadian case of Doe versus Jameson Bank. Now, in this case, a dispute arose between a bank and a customer over liabilities when the bank authorized certain transfers of funds from the customer's email account on the basis of certain fraudulent instructions received in a hacked email. Now, in this case, the Ontario Superior Court held that the bank was under no obligation to question the instructions. And it was in fact the lax security that the claimant had in not adequately protecting his email account that had led to the cyber attackers being able to send out these compromised emails in the first place. In any case, the bank was under no responsibility to question where and how these instructions came to them. As a result, even in the present case, Ms. Chakma is not under any liability to question why it's Ms. Jenny Liu from the claimant company and not Mr. Dwight Schrute who is sending her who's sending her an invitation for changed payments, just as it is not her place to question why they suddenly want to direct payment to the subsidiary company. Ms. Chakma.
Sorry, can I interrupt you there? What about the claimant's argument that firstly, one has to bear in mind this is 40 million euros and that one might want to be very cautious before transferring that amount of money based on a couple of emails. And the second point, which is that the bank account of the claimant was actually included in the contract. All Ms. Chakma had to do was pick up the phone. We've seen that the email addresses of various people from the claimant are in the genuine email signatures and the genuine emails. So I understand why you're trying to make a comparison with the bank, but we're talking about a contract between two counterparties on equal terms that has a bank account included in the contract. And most importantly, we're talking about 40 million euros.
Thank you for your question, Madam
Ms.
Arbitrator.
Zakaria, I'm sorry to do this, but if I could just build on that.
Absolutely,
We are talking about a due care, due diligence standard. And I have to tell you, the aspect of this part of the case that gives me some pause is the email exchange on page 22. The bottom of that page is an email from Mr. Schrute to Ms. Chakma dated 10 October. Copying Mr. Schultman and Ms. Newman, where he says that he's going to be on vacation, if I'm not mistaken. He'll be away from the office on 17 and 18 October. And then when she responds to that email on the 17th of October, she responds only to him and does not copy in Mr. Schultman or Ms. Newman. And I think it sort of goes to the same line of questioning.
Thank you for your question, learned arbitrators. If I could deal with Madam Arbitrator's question first and then subsequently address yours, would that be okay? Thank you. Madam Arbitrator, I agree that the contract itself involves sums of a very large and exorbitant amount. However, that doesn't increase in any way Ms. Chakma's liability to do any more than the reasonable care that she has already exercised. And the reason I submit to you, and the reason I submit this to you is also based on another Canadian case of Opus Consulting Group Limited versus Ardent and Capital Corporation. And now the reason I submit this case is because the facts of Opus Consulting are largely similar to what the tribunal has to consider today. In Opus Consulting, the defendant customer's payment for computer hardware bought from the claimant seller was fraudulently misdirected through a series of phishing emails, just like what has happened today. What is different is that in that case, the supplier obtained a pre-judgment payment order, which in Canadian jurisprudence is also a garnishing order, requiring the supplier to pay the buyer, requiring the buyer to pay the supplier a second time. However, the British Columbia Superior Court set aside this payment order on the grounds that the most serious question of the supplier's duty to protect its email system and the cybercriminal's ability to attack the supplier's servers was yet to be decided. And the reason, Madam Arbitrator, this is relevant to your question is because where the tribunal determines allocation of responsibility, it is necessary to contrast or rather compare the respondent's responsibility to undertake due diligence as opposed to the claimant's liability to protect their servers from attack and further harm. The reason I submit this is once again supplemented by the facts. If I may draw your attention to para 6 of the case study, in which it states that the claimant company was one of the few companies world over which had the technical know-how to make sophisticated and specialized drones. As we know from our own experience, these drones are often imbibed with facial recognition technology linked to biometric data, all of which is sensitive information. As a result, there is a higher burden on the claimants, if I may use the word, to protect their security systems. Now, if I may answer Mr. Arbitrator's question regarding Mr. Shruth's email ID. If I recall correctly, the learned arbitrator's question was that Mr. Shruth sent in an email on 10th October, to which Ms. Chakma did not respond until the 17th. Am I missing anything?
Well, that's correct, but I think the key point is that when she responded to that email, she did not hit reply all. She only replied to Mr. Shruth.
Thank you for your question, learned arbitrator. I can't say I have any law to submit on this particular question, but I will say that what Ms. Chakma may have done in this one email could be a common mistake that most of us do while engaging in email communication. It may not have happened intentionally. As you can see from Annexure 3, there is considerable communication, as there should be, between the claimants and the respondents. As a result, it's not possible, and sometimes it is possible that reply all is left out, and we do end up replying only to the sender of the email, as opposed to everyone else CC'd on the transaction. However, this in no way indicates that she has been negligent to the extent of inviting the phishing attack into the boundaries of this contract. And this is precisely where I may differ with my learned colleagues on the other side in saying that the respondents do fall under the first and third exceptions of the 3 exceptions laid out in the St. Lawrence testing case, which they cited. Now, if I may just refresh the tribunal's memory, the first exception was that victim A, which in this case would be the claimant company, and victim B, which in this case would be the respondent government agency, were communicating via email, and that the respondent was, if I may use the word, liable to rely on email communication of the claimant. Now, there is nothing in the fact sheet or even in the contract that expressly indicates what the mode or method of communication may be. We may argue that the respondents should have called the claimants and reconfirmed the payment. We may argue that email communication might not have served its best purpose, as it did not in this case, admittedly. But that doesn't mean there has been any strict violation of the contract. And that certainly doesn't imply that the last burden of averting the fraud or the phishing attack rested with the respondents. Similarly, I now come to the third exception, which is that there was negligence on the part of victim A, which is to say the claimant company.
Sorry, so can I stop with this? So is your argument that because there's no entire agreement clause or no notice provisions in the contract, that notices should be in writing or by email, etc., that's why it's gone?
Absolutely. Learned arbitrator, the only thing that we do know in the case study is that paragraph 11, the last line of which says the contract also set out that all payments were to be made to ABC GmbH's bank account by way of wire transfer, with all charges to be borne by the transferee. This only talks about the method of payment. And yet, this is not something that is reflected in the relevant clause in the contract. Now, if I may take since I'm on the issue, if I may take the learned tribunal to clause 3 of the contract at Annexure 1, which deals with purchase price and payment. The clause is—
Ms. Vakharia, what page number is that on?
Learned arbitrator, I would not. I'm using a physical copy, which doesn't have page numbers, but it is the very first page of Annexure 1. If the tribunal is with me, I may. Thank you so much.
Page 9 is the first page. What clause are you taking us to?
Madam Arbitrator, clause 3 at the bottom of the page, purchase price and payment, wherein it says that price per TRC 2645 drone unit is 50,000 euros, which is payable by NPPC as follows. It does not, and it sets out the timely payment requirements in the relevant subclauses, but it does not say that this payment is to be made specifically to ABC GmbH's account alone, which is why if we are receiving instructions from the parent company to direct payment to a subsidiary company, and by and large, we are bound to follow and not question those payment instructions. Nevertheless, I return now to the third exception of St. Lawrence trading, which my learned colleagues on the other side relied on, which is that the claimants did not have the adequate security to protect their servers. Now, once again, I take you to Annexure 5, which has the forensic report of Milloyd Consulting, which states that the claimant company employed a multi-stage system for mail check. They also had what we call as firewalls in protecting and in protecting their servers. Now, in putting forward practices against phishing outlined by the European Cybercrime Center, I would venture to submit before the tribunal certain additional practices that the claimants could have incorporated to ensure that they have a higher standard of security for their servers. I must note at the outset that this is particularly relevant because the claimant company is situated in Europe, and therefore the findings of the European Cybercrime Center would have particular significance for them. For instance, instead of using a firewall, as we know they have in the report of Milloyd Consulting, they could have used something known as an IDS software or an intrusion detection system. A firewall is a very preliminary software which protects the network at a very threshold level. An IDS tool actually has the ability to detect whether or not the network is under attack or whether it has already been breached, which would have been enormously useful in the present case. Similarly, they could have used, they could have taken benefit of a practice known as two-factor authentication, which is essentially a combination of a password and which is essentially a combination of having a password or a passcode and the user's biometric information. This is relevant because 2FA or two-factor authentication, as it is known, relies on a number of very useful factors. Knowledge factor, such as a passcode that only the user would know, a possession factor, such as an ID card or a security token, depending on their company practice, and inherence factor, a fingerprint, a retina scanner, something that is user dependent. And lastly, and most importantly, a location factor and a time factor. A location factor effectively tracks down the geographical locations from which emails are sent, and a time factor records at what point and at exactly what point in time and from where these emails have been sent. And these are useful not only because they provide that additional information for the tribunal to rely on, but they can also be customized. So if you are using two-factor authentication, then you can customize your location and time factors to allow your email communication to operate within a certain geographical limit and within a certain time period. So when we see in the Milloyd Consulting report, and I may take the tribunal to point number 2 of the summary of key findings on Annexure 5, which says that there was potential compromise and unauthorized access of Jenny Liu's Office 365 account from IP addresses belonging to various physical locations. This would have been detected at the outset. And as a result, possible phishing could have been stopped. Now I see, Learned Tribunal, I have only a minute left and the entire counterclaim to go. So with the permission of the tribunal, may I address the issue of the counterclaim, or would you have any questions for me?
Ms. Counsel, just before you proceed further, please help me understand this. The second email which came from D. Shrute at abc-tech.fe. Are you suggesting that this email was from the servers of the counterparty of the claimant, or is it fair to assume that this was a separate domain ID, a domain which was created and a separate email was sent from there?
Learned Arbitrator, now this would clearly be one of the spoofed domain addresses that the Milloyd Consulting report talks about.
Right. So if you just pause there,
yes,
it was a spoofed ID.
Yes.
Domain name and a domain and an email ID. Therefore,
yes,
this particular email can definitely not be attributed to the claimant, right? Or a failure of claimant's ability to protect its servers, etc.
Learned Arbitrator, if I may answer your question in this way. At no point are we suggesting that the claimants knowingly or deliberately aided in the phishing attack. They were probably asked.
No, sorry, I'm asking a different question. Is your case that the email from dshrute with the domain name dash.fe came from within the claimant's servers?
No.
Yes. So therefore, that email is definitely not the responsibility of the claimant. And anybody could have created any spoof IDs and could have sent you an email, right? Are we a item on that point?
Learned arbitrator, if I may submit to you this. Even though a third-party attacker, any third-party attacker could have created the spoofed email ID of Mr. Dwight Schrute, the information contained therein would have only been available to them because they were monitoring the communication between the claimant and the respondent by having unauthorized access to the claimant's servers. And the reason I submit to you this is, once again, if I may invite your attention.
Yeah, so that's fine. But that argues both ways, right?
I'm extremely sorry, Mr. Arbitrator. May I please ask you to repeat your question? I've been unable
sorry,
to catch it.
I'll say again. That argument of yours could cut both with those communications from your side of the server. That's also a possibility. I'm saying that that is the case, but that is a possibility, right? Now, specifically that email or cannot be attributed to the claimant. Now, you also made quite an extraordinary argument when you read out the force majeure clause. I believe it was at page 10. Let me just quickly go to it. Now, how do you say, or have you seen any precedent which suggests that an action specifically to one individual to the exclusion of the rest of the world amounts to a force majeure clause, force majeure event 1? And when you read this clause, the kind of inclusions that the force majeure clause has is an act of God, hostilities, war, rebellion, civil war rights, etc. Either some of these actions could not be a human action or could be an action which applies or affects a large number of people, countries, cities, states, etc. Right? So I'm not sure if a thief comes and breaks into my office, and I can say, look, my money was stolen and that was a force majeure. That could be something else, but perhaps not a force majeure. Can you just expound on it a little more?
Absolutely. Absolutely. Learned arbitrator, what I would do is, if I may answer the first question first, wherein you said that the argument that I just made would cut both ways. If I may once again, just to briefly answer that question, if I may invite your attention to point number 3 in the summary of key findings of Annexure 5, the forensic report, which says that after unauthorized rule creation and modification of Jenny Liu's account, there was also an automatic deletion of all emails received from the domain name nppc.in. So even if the financial details sent in Mr. Dwight Schrute's spoofed email ID had to be verified by the claimant, had to be verified by the respondent, even if they had reached out to the claimants, the hackers were closely monitoring and intercepting the communication between the two parties. As a result, it would have been difficult to say that if not in this way, the phishing attack could have been prevented in any other way. Now, secondly, learned arbitrator, if I may ask you for about 2 minutes further to address the force majeure claims argument.
Good.
Thank you so much.
Please go.
Learned arbitrator, I will submit to you 2 cases, one English and one Indian, to show you that it is not unusual for third-party interference, which would count as an act against an individual party and not towards the rest of the world, do in fact constitute a force majeure event in a contractual relationship. And having submitted to you those 2 cases, I will come back to the reading of clause 10 in the relevant contract. The first case that I submit for your consideration is that of Coastal Bermuda Petroleum versus VTT Vulcan Petroleum, which is an English case. It's a Court of Appeal case, wherein it was held that a seller's supplier who defaulted in the supply of fuel oil led to the seller being unable to perform his end of the contract. Herein it was held that the act of the third-party supplier was outside the seller's control and thus was a force majeure event absolving the seller of liability. Now, similarly, I submit to you the case of Taj Mahal Hotel versus United India Insurance Company Limited. At the outset, I do clarify that this case involved some degree of tortious negligence. So of course, I don't expect the tribunal to consider the tortious aspects, but I will submit it on principle alone, which is this, that a car which was parked at a hotel was stolen by one of the hotel's valets. And in coming to its decision, the court, this was a Supreme Court case, an Indian Supreme Court case, the Supreme Court came to the conclusion that despite diligence of the breaching party, the hotel, theft or negligence by a third party would be a force majeure event, and therefore the hotel could not be held liable for the breach. Now, if I may come to a reading of the relevant clause, which is clause 10 of the contract. Now, the clause reads as such, and I refer now to the third line of clause 10, where it says, or by events beyond its reasonable control. Now, this ties in with the case I cited when I began my arguments, which was the, if I may reiterate for the tribunal's benefit, this was the case in Dhanrajmal Govindram versus Shyamji Kalidas and Company, which said that a force majeure clause is to be given wide import to protect a party from anything that he cannot control, or anything, as our clause suggests, anything that is beyond its control. Do I sense a concern?
No, please go ahead.
Thank you. As a result, it is possible to say that a phishing attack is within the realm of the phrase events beyond its reasonable control. Similarly, if I invite your attention to the next sentence of the clause, which says such events include but are not limited to, therefore the specific events specified in clause 10 would not have to be read ejusdem generis, as the general principle of legal interpretation would go, but in fact would have to be read as an exception, which would cover a phishing attack if and when the facts and circumstances arise.
Thank you, Ms. Kamsi.
Thank you, learned arbitrators. If I may have 2 minutes.
Ms. Vakari, I'm sorry, just
yes.
very quickly before you go on, there was a word that you used about 15 minutes ago that I can't get out of my head, and that is when you were describing the payment of 40 million euros, you described the amount as exorbitant. Is it your position that this amount is exorbitant, and if so, does that have any relevance to the case?
Learned arbitrator, now the amounts are exorbitant because the technology that is being bought by the respondents is obviously extremely sophisticated and extremely specialized. So, and at no point is the tribunal, or I suppose even either party, is really alleging the amounts or the veracity and authenticity of the amounts. The amounts are what they are. The question now that really exists is, in respect of subclauses B and C, where the respondents have already made the payment, should we be asked to make the payment again? And in respect of clause 3.1d and clause 1 of the contract, should we be asked to pay at all, considering the fact, as I will now go on to submit with the tribunal's permission, the goods are unfit for purpose. So it's not the amount of, or the price of the goods that's really under dispute, but the ability or the necessity to pay that price in the first place.
Okay, thank you. How much time do you think you need for the remaining issues?
Learned arbitrator, if I have 2 minutes, I will submit my arguments in 2 minutes.
It's fine by me, my fellow arbitrators.
Yes.
Yeah.
Thank you so much. Learned tribunal, with respect to the counterclaim, the respondents make a very simple submission. We contend that the goods are not fit for purpose under clause 1.2 of the contract because the software installed in the drones inherently cannot function in conditions where PM 2.5 levels are above 1000. We see this in para 25 of the case study, wherein the claimants themselves have suggested that in order for them to function in levels above 1000, the software will have to be re-engineered. Which is why when my learned friends on the other side raised the concern that the respondents had the time to take a demonstration of the drones, not only at the claimant's lab, but also in Ferrari, where the goods were delivered, it was not the software that the respondents were testing. The respondent, being a consumer, will not have the requisite technical knowledge to test the software, but merely the drones as a whole that the respondent was testing. Now, if I may submit for the tribunal's consideration the case of Lambert versus Lewis, and this is a significant case, learned tribunal, because of how the facts progressed. In Lambert versus Lewis, the manufacturer of a towing hitch was sued for a breach of an implied warranty of fitness. I must note at the outset that in that contract, there was no express clause for fitness, after the towing hitch collapsed and caused an accident. Now, here it was held that fitness relating to the goods at the point in time of delivery indicated a continuing warranty that the goods would continue to be fit for that purpose for which the contract was made for a reasonable time after delivery, so long as they remained in the same apparent state, barring fair wear and tear. Therefore, when the claimants submit that the drones worked in other parts of Philandria and that New Riley was a remote exception, it is difficult for us to reconcile ourselves with this argument, because the claimants do have a continuing obligation to ensure that the goods that were delivered on 5th October 2019 continue to work on 22nd October 2019. Now here, if I may address very quickly the environmental discrepancies in New Riley that caused the malfunction in the first place. Now my learned colleagues have essentially contended that there was no way for them to know the high levels of environmental pollution in New Riley, even though there is something in the fact sheet to suggest otherwise. In the interest of time, I will take them at their worst case scenario, that there was actually no way of them. I'm so sorry, learned arbitrators. May I have 1 minute to summarize this point? Thank you so much. I will submit to you that even in the worst case, if they had absolutely no knowledge of the specific environmental conditions in New Riley, they would know their product the best. They have specific knowledge and of their product, given that the sophisticated software in the drone is possibly patented technology. As a result, they would have known that high pollution levels or any other environmental conditions interfere with the functioning of the drones. So right in the beginning, at the time of negotiation, if the claimants had merely informed the respondents of what conditions might hamper, hinder, or help the functioning of the drones, the respondents themselves would have been happy to supply environmental reports, climate change studies, and other data which would have helped them test their drones to see if the drones would even function in such high PM levels. Lastly, my learned friends on the other side have made a submission relying on certain world reports that the pollution level in New Riley was so far, far ahead of other cities like Delhi and Dhaka. To which my humble submission is, if the claimants were aware of how unimaginable the pollution levels of 1000 can be, then it was perfectly within their knowledge and it was perfectly within their technical understanding that the drones would not have functioned in New Riley either way. So even at the time of supplying the contract, if they would have told us that the drones will function in your country, but not in this particular place where the pollution levels are so high, we might have not been in the situation we find ourselves in today. If the tribunal has no further questions, I would like to conclude. Thank you so much for your time.
Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you for your submissions, learned counsels. We will now ask the arbitrators to deliberate upon the submissions and arrive at a conclusion regarding the outcome.
May I ask about rebuttal?
Are we deliberating in this chat room or somewhere else?
Hi, Sapna. The deliberations will happen here, but I think Vignesh, one of the participants asked for a rebuttal, sir. Rebuttal. Are we done with that?
Oh, right. We actually have the rebuttals and sir. I'm extremely
sorry. I believe
sorry.
they had reserved the time, so
yeah, they have. I'm extremely apologetic of the same. Yeah. The respondent procedure speaker would like to go first.
Yes, thank you. Learned arbitrators, in the next 2 minutes, I'll just briefly submit a few points of rebuttal on the procedural issues. Firstly, the claimant relies on the case of BGS Soma as a case that runs directly contrary to the ruling of the Supreme Court in Hardy. However, following the rule of precedence, it can be seen that both judgments have been delivered by benches of co-equal strength, namely 3 judge benches, and therefore the ruling in BGS Soma cannot overrule another judgment of a bench of the same strength, which is 3 judges, as in Hardy. Therefore, the test that this tribunal should employ is to see which case lays down the law more elaborately and accurately. And in my submission, that will be Hardy, because Hardy takes the very fundamental principle of distinction between a venue and a seat, and it implements it in the way a tribunal or a court is supposed to interpret the arbitral agreement between the parties, while cases like BGS Soma merely operate on a presumption that venue will equal to seat, and therefore Hardy lays down the law elaborately and more accurately than BGS. Secondly, as regards the submission on Swiss timing, in Swiss timing there was one very interesting fact that distinguishes it from this case, which was that clause 29 of the contract in the case of Swiss timing had a warranty against corruption and specified that parties shall not engage in corrupt acts. And that gave an arbitral tribunal a contractual mandate to be able to adjudicate over an issue of corruption, wherein in our case, a tribunal does not have such a contractual mandate. And lastly, as regards procurement of goods, public procurement, the claimants have relied upon the Philandrian Public Procurement Act. However, there are other elements to also be considered outside of the Act, as seen in the Manual for Procurement of Goods issued by the Ministry of Finance in 2017. In cases of emergency procurement of goods, they must be procured from registered buyers, they must be procured from registered sellers. Reasons as to why those the procurement was taken on an emergency basis must be noted and recorded. And these elements, of course, are elements of, again, administrative decisions. And this tribunal would not be able to adjudicate upon those matters. And learned arbitrators, my last submission is as regards law of governing the arbitral agreement, determining arbitrability of an issue. The tribunal must also keep in mind the law of arbitrability as in the enforcing country, as laid down in Article 5(2)A of the New York Convention and subsequently Section 48(2)A of the Indian Arbitration Act. In order for enforcement of an award, to be enforceable, the subject matter of that award must be arbitrable subject matter. So this tribunal must in all circumstances consider the law of arbitrability under Philandrian law. I am grateful for this learned tribunal's time.
May I ask one question about that?
Yes.
So does it matter then in your submission whether Philandria is the only place of enforcement or not?
Learned arbitrator, Philandria will definitely, what I can tell the tribunal is that Philandria will definitely be a primary place of enforcement, especially if the award goes in favor of the claimant, as the company NPCC respondent is located in Philandria. And even for the respondent, it may choose to enforce in Philandria primarily due to the possible availability of some of the claimant's drones, which are movable property that can be attached in an enforcement proceeding.
Thank you.
Thank you, learned arbitrator.
And just on one other point,
yes.
Do you have a response to the submission that was made that the import that manifest and the import given to the word manifest is that it causes a very high standard to be applied?
Indeed, learned arbitrator, as I've submitted in Trans Global versus Jordan, manifest implies that that the conclusion has to be clear and apparent to the tribunal. But in this case, we have, as the respondent, satisfied that requirement because it is it is made plain and clear to this tribunal that it cannot adjudicate upon matters of public policy and public procurement, as well as on matters of corruption, at least in the context of these facts where the corruption is serious and has implications in the public domain. And since that conclusion is clear, even the requirement of manifest under Rule 29.1 of the SIAC rules will be satisfied in my submission. I'm grateful to the learned.
Now, honorable members, if I may take a minute and a half to reply to the rebuttals given by the opposing counsel. First, I would reply to him on the issue of arbitrability. All right, even if the tribunal were to look at arbitrability from a Philandrian perspective and it would follow the test as laid down in Booz Allen versus SBI Home Finance, which merely proscribes actions in rem. However, the parties have demanded actions in personam from the tribunal, and such action, and if therefore, since an action in rem has not been demanded, this issue is even arbitrable under Philandrian law. Secondly, now the council seems to contest my application, my claim regarding Hardy exploration. However, does not seem to realize that I had not distinguished its authority, but distinguished it on facts, in that the facts of the case do not apply to this case, while pointing to the reasons of commercial sensitivity as to why the seat should be London and not Philandria, while he seems to only rely on the apparent authority of the case, rather than focusing on whether it applies to the given facts or not. Thirdly, with respect to the rules that the procurement rules that he had cited, though it is uncertain whether those rules have been made pursuant to the Public Procurement Act. Therefore, if there is a conflict between public procurement rules and the public procurement statute, which is given by a legislature, the provisions of the statute would automatically take precedence since they come from a higher authority than an executive order. For this, then that would be all, members of the tribunal. Thank you.
Am I audible?
Yes, you are.
Yeah, thank you. Members of the tribunal, if I may just take a minute to present my rebuttals for the merits. So the first, I'd like to ask two questions to my opposing counsel. The first one is regarding her claim that phishing has to be brought under the purview of force majeure. So if you look at statistics in 2019, phishing has accounted for about 90% of the data breaches happening all over the world. So phishing is not so uncommon in the current cyber era that we are living in, especially in the 21st century, when almost all corporates are advised to take precautionary measures to stop phishing. In such a scenario, how can a phishing attack be termed as unforeseeable and hence be brought under the purview of the force majeure, especially keeping in mind the relatively high threshold that Philandrian courts, the Philandrian courts in fact take to prove force majeure or bring a case under force majeure. And also the opposing counsel had completely evaded the issue of payment under clause 3.1d of the contract, which was supposed to be paid to us, but they haven't still done the payment. So these are the two questions. Thank you.
Thank you.
May I begin?
Please do.
Thank you. Learned Tribunal, I will restrict my rebuttal to the 2 points that my learned friend has raised. Firstly, he's submitted that phishing attacks are becoming more and more frequent, especially in the past year, to which the respondent's humble submission is, if that is so, with reliance on the data that they have given, then that's all the more reason for the claimant to have better and more adequate security to their servers than what they presently have under Annexure 5, which has the Milloyd Consulting Forensic Report, in order to safeguard against the very attacks that they think are predictable. Because at the end of the day, it is the claimant's servers that have been hacked and not the respondents. Secondly, I see my learned friend on the other side had a concern that we didn't address clause 3.1d. If I may just clarify for everyone's benefit, The respondent's claim is that non-payment under clause 3.1d of the contract is inherently linked to the unfitness of goods under clause 1.2. As a result, if the tribunal is to hold that the goods are unfit under clause 1.2 of the contract, there is no question of payment that arises under clause 3.1d, because there has been no delivery of the third tranche which has been made. Thank you so much, Learned Tribunal, for giving me such a patient hearing.
Hi, everyone. I would like to thank all the participants for their submissions. And I would like to thank the judges, especially for taking out time on a Sunday evening and afternoon to make sure that we all learn something out of it. And it's been an enriching experience for the participants. We can deliberate on this platform itself after we will ask the participants to leave this meeting in a while. Just in a while, the valedictory ceremony will take place at around 7:30 p.m. Indian Standard Time, and we request everyone watching us on the live stream on YouTube to please join us on the valedictory ceremony as well for the announcement of prizes. I would like to just make another request, is to please turn on your video so we can have a screen picture of the grand finals. If everyone could turn on their videos, please. Yes.
When is this? I think, yeah, perfect.
Yeah. 3, 2, 1. That's great. Thank you. Thank you so much, everyone. I would like to ask the participants to leave this meeting for a while, and we'll start with the valedictory ceremony at 7:30 p.m. Thank you so much, everyone.
Thank you.